Welcome to the Deep Dive. This is the place where we cut through all the academic noise, we ignore the information overload, and get straight to the high-yield ethical and legal frameworks you need.
And not just to be a good doctor, but to really master the situational judgment that's required for those top scores in the MSRA.
Today, our mission is, well, I think it's probably the most critical one we've tackled. We're getting into the core professional duties that really define junior medical practice here in the UK.
We're talking about capacity, candor, and confidentiality. And these, they aren't just abstract concepts from a textbook, are they?
Not at all.
They're the absolute bedrock of good medical practice, the new 2024 guidance. And honestly, mastering them is the difference between just scraping a pass in the SJT and placing high enough to get your top choice job.
Right. And our sources for this are pretty comprehensive. We're synthesizing the legal spine, so that's the Mental Capacity Act 2005, CQC Regulation 20, with all the professional expectations laid out by the GMC.
And we're filtering all of that through the lens of high-stakes SJT prep materials. We're really focusing on those high-frequency scenarios where these duties, well, they crash into each other.
Exactly where the conflict is.
Exactly. The goal here is rapid, deep internalization of the frameworks, the ones that let you balance patient autonomy, clinical safety, and, your own professional accountability.
Because when those three conflict, and they will.
They will. The law dictates the pathway, and the SJT scores reward the doctor who follows that pathway precisely. No shortcuts.
Okay, let's set the stage immediately. I want to jump into a dilemma that feels like it's been ripped right out of the exam room. This is that high-tension, multi-layered problem designed to test all three pillars at once.
Let's do it.
Okay. You're consulting with a patient. After a full assessment, it's clear they have the mental capacity to make their own choices. They then disclose to you a very serious, ongoing safeguarding concern. It involves another vulnerable adult.
Yeah.
And they ask you, they plead with you to keep this absolutely secret, citing their right to confidentiality.
Okay, a classic conflict.
But at the same time, your phone rings.
Okay.
The police. They're requesting urgent access to the patient's full clinical notes for a recent complicated assault investigation. So what do you do first? And how on earth do you navigate those conflicting duties? Capacity, confidentiality, public interest. They're all pulling in different directions.
That tension, that's the SJT in a nutshell, isn't it? It forces you to immediately prioritize. You have to triage your professional duties just like you triage a patient.
It's a real pressure cooker.
It is. You've got the patient demanding autonomy and confidentiality on one hand, but on the other, you have this clear duty to protect others, the safeguarding element, and a legal request from the police.
So where do you even start?
Okay, so if we just strip away the fear, the kind of emotional pull of the scenario, there's a one-sentence core truth that should guide every single action you take in this complex space.
And that is?
Safety and legality demand clear documentation and the minimum necessary disclosure, prioritizing the right process capacity first, minimum necessary, document everything over speed, emotion, or, convenience.
Right, process over panic.
Always. This topic, it matters so much, both clinically and for the exam. Clinically, these principles are just the non-negotiable bedrock of good medical practice. Get these wrong, and you risk not just patient harm, but GMC referral, litigation. It's serious.
They define everything. How you make decisions, how you react when errors happen.
How you manage sensitive information. Exactly.
Yeah, for the SJT, you cannot afford to miss the structure here. These areas, capacity, candor, confidentiality, speaking of, they're consistently the moderate to hard questions, aren't they?
They are. And the difference between a high score and a mediocre one often comes down to whether you choose the answer that sticks rigidly to the legal framework like the Mental Capacity Act, or whether you take a tempting shortcut.
A shortcut that feels right in the moment.
Precisely. The SJT rewards structured, lawful, documented thinking. The most common low-scoring trap is delaying action, ignoring the formal legal process, or deviating from those key requirements.
Like skipping the two-stage capacity test.
Exactly that. Or failing to use the freedom to speak up guardian when there's a systemic issue. You have to show the examiner you understand the hierarchy of duties. It's a test of process.
Okay, so let's unpack this. We're going to use our triple duty framework. We'll look at the three core pillars that structure the safe doctor's professional life. Capacity and consent, then openness and accountability, and finally, privacy and information governance.
A solid structure.
Right. So we begin, as all good decisions must, with pillar A, capacity and informed consent. This is the foundation, isn't it? Set by the Mental Capacity Act 2005 and then reinforced by the Montgomery Standard. What's the foundational expectation the GMC has for us on consent?
The expectation is crystal clear. Consent must be voluntary, it must be informed, and it must be given by someone with capacity. We have to operate in a model of shared decision-making.
Which is a move away from the old way of doing things.
A huge move away from the old paternalistic idea of just telling the patient what to do. The safest doctor, the high-scoring doctor, always leads with a capacity-first mindset. They adhere strictly to those 5 statutory principles of the MCA.
I want to zero in on that capacity-first idea. It's not just about testing capacity, is it? It's about enabling it first.
Absolutely. That's MCA Principle 2 in action. You must assume capacity unless it's established otherwise. And, crucially, Principle 3 says a person isn't to be treated as unable to make a decision just because they make what you or I might think is an unwise decision.
So you have to try to help them make the decision first.
You have to. The supportive measures are critical. Are you giving the patient enough time? Is it a quiet, private space? Are you using simple, jargon-free language? Have you got a professional interpreter, not a family member? Maybe using visual aids?
All of that has to happen before you even think about the test.
Yes. Only when all those reasonable steps to support the decision-making process have been exhausted, and you still have doubts, only then do you proceed to the formal 2-stage test.
Okay, let's detail that 2-stage test,
Yeah.
because I think skipping it or misapplying it is a massive SJT trap.
It is, and it's mandatory under the MCA. So stage 1 is the diagnostic test you have to ask. Is there an impairment of or a disturbance in the functioning of the mind or brain?
And that has to be a specific thing.
It has to be demonstrable. Is it dementia, delirium, acute illness, intoxication, a learning disability, severe depression? You must have a clinical reason. If there's no impairment, capacity is assumed. End of story.
And if there is?
Then you move to stage 2, the functional test. This asks, is the person unable to make this specific decision because of that impairment? And the inability to decide is shown by failing one or more of 4 criteria.
Okay, what are the 4?
First, can they understand the relevant information? Second, can they retain it long enough to make the decision? Third, can they use or weigh that information as part of the process? And fourth, can they communicate their decision? And that can be, by any means, blinking, squeezing a hand, whatever.
And if they fail on any one of those?
If they fail on any one of those 4 points because of the impairment, then capacity for that specific decision at that specific time is lacking.
What about fluctuating capacity? That comes up all the time. A patient with delirium who has moments of lucidity.
A high-yield clinical point for the exam. You must try to do the assessment when they are most likely to have capacity. If the decision is urgent, you have to document the fluctuation, and if they lack capacity at the point of decision, you act in their best interest.
Well, you don't just leave it there.
Never. You must keep their capacity under constant review. You're always aiming to make the decision when they're lucid, if it's clinically safe to wait.
Okay.
Yeah.
Now, let's say capacity is confirmed. We then move to the standard of disclosure, and this is where the Montgomery Standard comes in. For anyone revising, how did that 2015 Supreme Court ruling change how a doctor has to approach consent?
It was a monumental shift. It completely moved us away from the old paternalistic Bolam test, where doctors basically decided what risks were relevant. Montgomery requires you to disclose material risks and reasonable alternatives.
Including doing nothing.
Including the option of doing nothing. And crucially, a risk is material if a reasonable person in that patient's position would attach significance to it, or if you, the doctor, know or should reasonably know that this particular patient would attach significance to it.
So it's all about tailoring the information to that individual. Can you give us a concrete example of that?
Of course. Imagine you're a hand surgeon discussing a carpal tunnel release. For a typical office worker, the main material risk might be recurrence of symptoms. But what if your patient is a concert pianist or a precision watchmaker? Suddenly, a temporary loss of fine motor skills or even a very small risk of a surgical site infection becomes highly material. It threatens their entire livelihood, their identity.
So your documentation has to reflect that conversation.
It has to show you discuss the specific impact of that risk on that patient's job, their hobbies, their values. The SJT demands evidence of this patient-centric, shared decision-making model. You can't just use a generic consent form.
That makes perfect sense. So now let's look at the flip side. Capacity is lacking. We mentioned acting in their best interest. This is where a lot of doctors can rush things. What does the MCA Best Interest Checklist, Section 4, really require us to do?
Rushing is the trap. The best interests framework is mandatory when capacity is lacking. That checklist, it forces us to consider the least restrictive option, that's Principle 5, and critically to consider the patient's past and present wishes, their feelings, their beliefs, and their values.
And how do you find that out if they can't tell you?
That's the key. It requires consultation. You have to talk to anyone involved in their care or interested in their welfare, family, friends, carers.
And before you proceed with any action, there are those non-negotiable legal documents you have to check for.
Yes, absolutely. First, you must always check for a valid and applicable ADRT, an advanced decision to refuse treatment. This is legally binding if it's correctly documented and applies to the current situation.
Even if it's for life-sustaining treatment?
Even then, if you proceed with the treatment in the face of a valid ADRT, you are committing an assault. It's that serious. Second, we check for an LPA, a lasting power of attorney for health and welfare.
And the LPA attorney is the decision maker.
They become the legal decision maker when capacity is lost, yes. But, and this is a key point, their decision must still follow that Section 4 best interest checklist. They are not empowered to just decide whatever they like. They step into the best interest process on the patient's behalf.
Okay, what if the patient is unbefriended? No family, no friends, no LPA, and they need serious medical treatment or, say, a move into a care home?
That's a specific trigger. It triggers the statutory requirement to instruct an IMCA, an independent mental capacity advocate. The IMCA provides independent representation for that unbefriended patient.
And failing to do that is a big mistake.
A huge procedural breach of the MCA, and it will score very poorly in the SJT. If the criteria are met, serious treatment, long-term accommodation change, certain safeguarding concerns, you must instruct an IMCA, and you must document that you've requested one.
Before we move on, a quick word on children and young people. How do these principles shift?
Good question. For 16 and 17-year-olds, they are presumed to have capacity, just like adults. That's under common law. For those under 16, the rule is Gillick competence.
Means?
It means, can they demonstrate sufficient maturity and understanding to really comprehend the proposed treatment, including its risks and alternatives? If they are Gillick competent, they can consent.
But what about refusal?
That's the tricky part. In cases of refusal of treatment, especially life-saving treatment, their Gillick competence can potentially be overruled by someone with parental responsibility, or by the courts acting in the child's best interests. The key takeaway for the SJT is, get senior input immediately and document your capacity assessment robustly.
Okay, that covers capacity very thoroughly. So if capacity is all about the individual's legal rights, our next pillar, Pillar B, openness and accountability, is about our duty to the system, to the patient, and to the safety of our colleagues. Let's start with the duty of candor.
Right. Candor is all about being open and honest with patients when their care goes wrong. It's about restoring trust and, just as importantly, promoting organizational learning. And as you said, it operates on two crucial levels that the SJT loves to test, the professional and the statutory.
Let's define the professional duty first. This seems to apply pretty broadly.
It does. The professional duty of candor applies whenever harm or even the potential for harm occurs. The action you take must be immediate. You have to apologize promptly.
Even if you don't know what happened yet?
Yes. You explain truthfully what is known and what is not known. You offer continuing support, and you ensure the patient is involved in any learning review. The GMC, NHS resolution, the CQC, they are all absolutely clear on this. An apology is an expression of regret. It is not an admission of legal liability, and that piece of reasoning is critical for the SJT.
So if a patient has a complication and the root cause isn't known yet, the high-scoring action is still to say, I'm sorry this has happened right now, not wait 3 weeks for the full investigation report.
Exactly. Waiting breaches the duty. It prolongs the patient's distress and completely undermines their trust of you and the system. You apologize for the situation they find themselves in. You explain the immediate steps you're taking to find out why it happened, and you document that discussion. That is the professional standard.
Okay. Now for the stricter version. The statutory duty of candor, which is under CQC Regulation 20. Why is understanding the specific threshold here so important?
Because the statutory duty imposes formal, auditable notification requirements on the provider, so the hospital trust, the GP practice, it only kicks in when an incident causes or could cause moderate or severe harm.
Or prolonged psychological harm.
Or prolonged psychological harm, which is defined as lasting 28 days or more.
That's a key distinction. What would count as moderate harm in this context?
Moderate harm usually involves some form of temporary harm that requires a change in treatment or procedures. Think of an unplanned return to theater, a fracture, a significantly prolonged hospital stay.
So a retained foreign object after surgery.
A perfect example. A retained swab, a serious medication error, severe surgical complications. Once that threshold is crossed, the organization must strictly follow CQC Reg 20. That means formal notification, a written account of the incident, a documented apology, and details of the investigation and the learning outcomes.
So for the SJT, you need to spot the severity and know when that formal process has to kick in.
Precisely. You need to identify the threshold.
Okay, let's shift to proactive accountability. Speaking up, this is about acting before harm happens or when you see systemic failings. What's the immediate non-negotiable first step here?
Immediate action to make the situation safe. That is always step one. If you see an impaired colleague, faulty equipment, a system failure in Hanover, you must intervene immediately to halt the unsafe practice.
Even if it's awkward.
Patient safety trumps team harmony or any fear of conflict, every single time.
And what's the formal protected route for escalating those bigger concerns about institutional or systemic safety issues?
You have to use the formal hierarchy. It should look like this. First, your line manager or a senior consultant. Then the clinical governance department or the incident reporting system like DODIX, and then the crucial independent safeguard.
The FTSU Guardian.
The freedom to speak up, FTSU Guardian. The Guardian is independent, they offer confidential advice, and they provide a protected route for raising concerns that management might otherwise ignore or, worse, suppress.
We should probably mention the legal protection here, because that's what encourages people to escalate.
We have to. The Public Interest Disclosure Act, or PIDA 1998, gives legal protection to workers who make what are called qualifying protected disclosures. If you follow the correct internal or external routes, so to the FTSU Guardian, or even to the CQC PID, protects you from detriment or unfair dismissal.
And the SJT rewards that.
The SJT rewards you for using these formal protected routes, for keeping objective records, and for prioritizing patient safety over personal loyalty or comfort.
That brings us neatly to our third and final pillar. Pillar C, confidentiality and information governance, or IG. The core principle sounds straightforward: protect identifiable information. But the application is incredibly complex, isn't it? Guided by the Caldicott principles.
The complexity comes from the fact that confidentiality isn't absolute. It can be breached with consent or, in very rare, strictly defined legal or public interest circumstances. The central rules, guided by Caldicott, are all about proportionality and the minimum necessary disclosure principle.
Let's break down that minimum necessary rule because it feels central.
It is. It means you must only share the absolute smallest amount of information necessary to achieve the stated purpose. So if you're updating a GP about a discharge, you send the key discharge summary points. You do not send the patient's entire 10-year history of notes, which might contain sensitive, totally irrelevant data.
So sending the whole record, even to another doctor, is a failure.
It's a huge IG failure. It's a breach of the minimum necessary rule, and it massively increases the risk of a serious data breach.
Okay, so let's distinguish between the two main ways we share information for direct patient care versus requests from third parties.
Right. Sharing for direct care, so within the immediate multidisciplinary team for the purpose of treatment, is generally justified on a need-to-know basis. This relies on common law duty of confidentiality exceptions and what we call implied consent.
First,
the nurse needs to know the medication dose. The radiologist needs to know why you've requested the scan. This is generally fine without getting specific GDPR consent for every interaction, as long as it's the minimum necessary and it's documented.
But the second you step outside that immediate care team, the requirements change completely.
They do, drastically. Sharing with third parties or for non-care purposes, so we're talking relatives, employers, the media, the police, insurance companies, almost always requires explicit, informed consent from a patient with capacity.
Or a clear legal justification.
Or a documented, clear legal or ethical justification. If the police call, you have to clarify their exact legal justification. Do they have a court order? Or are you acting in the public interest to prevent serious harm? You have to verify their identity and the exact scope of what they're asking for.
And never give details to a relative just because they sound concerned.
Never. Not without verifying consent first. That is a classic trap.
Finally on this, the pervasive threat of digital breaches. Social media, WhatsApp, email.
The rules are the same regardless of the channel. Professional standards demand that you use approved, secure channels. That means EPR systems, secure NHS email. using personal messaging apps like WhatsApp or Instagram DMs for identifiable clinical data.
Even for a quick photo or question?
Even for a quick question, it's an IG failure. Why? Because they are not approved clinical record systems, they bypass all the IT governance controls, and they are inherently insecure in a professional context. Any significant communication has to be immediately logged in the clinical record.
Okay. We've laid the groundwork for all three duties now, but the real test is how you synthesize this huge mass of legal and professional guidance into a single high-scoring action sequence for a complex SJT scenario like the one we started with.
Exactly. You need a process.
So let's get into the exam strategy. What are the high-yield actions, what to do first, next, and last?
The key, especially when you're under pressure in a scenario, is to apply a unified multi-duty framework. We call it the make-safe process. The SJT is very often testing your understanding of the correct procedural sequence.
Okay, what's step one?
Step one is make safe now and assess capacity. This is always the immediate clinical or safety intervention combined with that foundational legal check. So, stop the immediate harm, prevent clinical deterioration, halt an unsafe practice.
And the capacity bit.
Crucially, for non-urgent matters, you assess capacity first. If a patient is septic and delirious, you treat immediately. That's under the MCA's urgent treatment provision in their best interests. But if they're refusing treatment in a non-urgent context, you must assess their capacity with the two-stage test before you do anything else.
That initial assessment is totally non-negotiable. So what's step two?
Step two is clarify lawful basis and confidentiality status. Before you share anything, disclose anything, or override a decision, you have to establish your legal grounding. If they have capacity, is there valid Montgomery consent? If they lack capacity, is there an ADRT or an LPA?
And for disclosure?
For disclosure, you must determine if it falls under direct care, a statutory duty like notifying UKHSA, the public interest to prevent serious harm like with the DVLA or child abuse, or if you need explicit consent. You have to know your legal basis.
Step three is the action itself, but it sounds like it has to be done with extreme proportionality.
That's the perfect word for it. Step three is disclose or escalate, but only the minimum necessary. This is where you execute the decision. You share the absolute bare minimum of information. You do it via an approved, secure channel, and you only share it with the correct authority.
The right person.
The right person. That might be your senior, an IMCA, the FTSU guardian, or an external agency like the DVLA. And critically, you must inform the patient about the disclosure, unless doing so would raise the risk of serious harm or prejudice, a serious crime investigation.
And finally, the step that ensures your accountability.
Step 4. Document the rationale and review plan. This is where you protect yourself and the patient. Your contemporaneous note must cover everything. Your assessment of capacity or risk, who you consulted, the decision you made, the legal or ethical basis you relied upon.
So you'd literally write, disclose to DVLA under public interest as patient refused to notify.
Precisely that. And you'd include a plan for review or follow-up. That documentation is your shield.
To make that sequence stick, especially when you're revising quickly, we need those high-impact mnemonics.
Yeah.
Let's start with the one for capacity and consent structure. We're calling it consent.
Right. Consent is your quick reference checklist. It helps you ensure you're meeting the Montgomery standard and the MCA principles when capacity is present. So C is for
Capacity first. Always check and support it.
exactly. O is for options and alternatives, including the choice of doing nothing. N is for needs and values, tailoring the discussion to what matters most to this patient.
S would be
Specific material risks. That's the Montgomery duty right there. E is for enable understanding, using interpreters, time, simple language.
N.
Note decision. A contemporaneous record in the notes is vital. And finally, T is for talkback safety net. That's ensuring they know what to look out for and how to seek help later.
That's brilliant. It covers the whole patient-facing discussion. Now, for confidentiality and that secure information flow, we use LOCKIT. This is essential for preventing those IG breaches.
LOCKIT helps you vet any disclosure request against the Caldicott and IG standards. L is for legitimate purpose. Why are you sharing this? Is it for care, a statute, or the public interest?
All must be only necessary info.
Only necessary info, your minimum necessary rule. C is for consent or condition. What's the lawful basis? Explicit consent, implied consent for direct care, a statute, or a public interest justification.
K is for keep secure. Use approved, secured channels.
Always. I is for inform appropriately. Transparency with the patient where it's safe to do so. And T is trace and notes. Document the who, what, why, and how of the disclosure.
And finally, for accountability and safety, both reactive, so candor, and proactive, speaking up, we have speak up.
Speak up frames your duty when those organizational or colleague safety concerns come up. So S is stop harm. Immediate safety action is paramount.
P must be proper route.
Proper route. Use the seniority ladder. Senior, then governance, then the FTSU guardian. E is for evidence log. Document objective facts, dates, times, not just hearsay.
A for anti-detriment.
Anti-detriment. Taking steps to protect yourself knowing that PI day exists. K is for P. Keep follow-up. Make sure the concern is actually addressed, not just ignored. U is use, FTSU. Always loop in the freedom to speak up guardian for those systemic issues.
And P.
P IDEA protects. Knowing your legal protection under the Public Interest Disclosure Act.
Those frameworks give us a really solid structure. Let's now look at the specific situational patterns the SJT uses to try and trip you up.
Let's do it.
Pattern 1. Capacity versus unwise choices. We can call this the autonomy test. It's a classic. A patient is refusing life-saving treatment, but otherwise seems totally fine, and it causes the doctor to panic.
And what's really being tested here is your strict adherence to the MCA principles. Remember, Principle 3 means an unwise choice does not equal incapacity. If a patient is choosing to smoke heavily right after a heart attack, that's unwise. But if they understand the risks, they are capacitated.
The SJT wants to see you respect their autonomy, even if the outcome looks terrible from a medical perspective.
Exactly. So the safest, highest scoring action is to apply that two-stage capacity test thoroughly, documenting your functional assessment clearly. If they are capacitated, you ensure you've met your Montgomery duty, explain all the material risks and reasonable alternatives one more time.
And then you have to respect their decision.
You must respect the refusal and document the discussion clearly. The biggest trap is assuming they lack capacity and immediately trying to get consent from a relative. Relatives have no default right to consent to medical treatment for a capacitated adult, or even an incapacitated one without an LPA.
Right. Pattern 2. The need for external disclosure. We'll call this the exceptions test. This forces that conflict between confidentiality and public safety. So let's go back to our opening dilemma. The capacitated patient demands secrecy about a safeguarding concern, and the police want the full notes.
This is testing whether you understand the hierarchy of duties when you're faced with serious harm or a statutory duty. Confidentiality is the default, but you must override it if it's required by law-like mandatory reporting of certain infectious diseases to UKHSA, or if it's necessary in the public interest to prevent serious harm.
Serious harm like?
Like serious safeguarding risks, terrorism, or reporting an impaired driver to the DVLA.
So how would you handle the two parts of that dilemma sequentially?
Okay, first, you address the immediate safety and safeguarding risk from the patient's disclosure. You have to explain to the patient that while you respect their confidentiality, your professional duty compelled you to act if someone else is at risk of serious harm.
And then you disclose.
You would then disclose the minimum necessary information to the relevant safeguarding team, and you'd inform the patient unless doing that would raise the risk to others. That's part one.
And the police request.
Secondly, the police request for full notes is a massive red flag. You do not hand over full notes. You clarify their legal basis. If they provide a court order, you comply, but only with the information specified in that order.
And if they don't have one?
If they're relying on public interest for their assault investigation, you share the minimum necessary factual information that's relevant to the assault, and you document your public interest justification clearly. You're using the LOCKIT principles, O and C. You
Right.
never, ever share the entire record.
Got it. Pattern 3. An organizational or systemic failure. This is the speaking up test. It's testing your commitment to systemic safety versus your own personal comfort.
This is testing your understanding of the GMC duty to act when the system itself is unsafe. You have to prioritize institutional safety over any sense of internal loyalty. The highest scoring actions always involve using those formal protected routes.
And what's the common failure here? What do people do wrong?
The common failure is delaying, or just telling a junior colleague, or worse, going directly to the media before you've exhausted the internal channels. The best action is immediate intervention to stop the unsafe practice. That's step one.
Followed by
Robust documentation and structured escalation, line manager or consultant, then clinical governance, and then the FTSU guardian for any systemic or ongoing concerns. The SJT rewards the choice that provides objective evidence and uses the protective function of the guardian and PID.
Okay. Pattern 4. The complex incapacity scenario. The MCA process test. This is where you have serious treatment decisions for an unbefriended patient.
This tests your strict adherence to the MCA best interest process, so Section 4. You have to demonstrate that you've exhausted all the means of consultation and that you've checked for any legal instruments.
The crucial action here is all about the IMCA, isn't it?
Precisely. The best action is to check for an LPA or ADRT first. If the patient is unbefriended and they need serious treatment or a long-term accommodation change, you must instruct an IMCA. Then you make the least restrictive decision possible, fully informed by that Section 4 checklist, past wishes, values, and you document everything fully.
And the major trap.
The major trap is allowing a distant relative, who is not an LPA, to sign consent forms. It's legally null, and it just undermines the entire MCA framework.
Okay, last one, pattern 5. The digital or social media breach, we'll call this the security test, applying those IG standards to the modern workspace.
This just tests your understanding that the Caldicott rules apply everywhere. If a colleague posts a photo with identifiable patient data in the background, or if you get a clinical question in a direct message, your professional duty is immediate mitigation and redirection.
And what does immediate mitigation look like?
It looks like asking for the deletion or removal of the identifiable content immediately and explaining the severity of the confidentiality breach. If a patient DMs you for advice, you immediately reply, state you cannot give clinical advice on that channel, and you redirect them to secure official channels like the GP surgery phone line.
And you document.
You document that interaction in the patient's record, even if it was a personal DM, if any clinical information was involved. The trap is ignoring it or arguing that because WhatsApp has end-to-end encryption, it's safe. It doesn't matter because it's not a governed clinical record system.
Okay, we absolutely have to be explicit about the low-scoring decoys now because they often appeal to our basic human empathy, but they fail that structured, lawful standard that you need for top SJT marks.
Yes, let's go through the traps.
Let's start with the danger of delaying necessary care.
Right. The trap answer is delay emergency care for signatures or for an investigation. This breaches the fundamental duty to prevent harm. The MCA specifically allows for urgent treatment in a patient's best interests without a prior capacity assessment or court approval if waiting would compromise their life or health.
In an emergency, safety first.
Safety is paramount. The SJT will always penalize delay when immediate action is needed.
Okay, the perennial trap about involving family and capacity decisions.
The answer will look like, just get consent from a relative. This is fundamentally wrong under the MCA. Relatives are consultees, they're valued for their insight into the patient's values, but they are not decision makers unless they hold a valid health and welfare LPA. Choosing that option shows you don't understand the legal framework.
The autonomy versus risk conflict again.
The trap is thinking. An unwise choice means they lack capacity. This directly violates MCA Principle 3. The riskiness of the choice is irrelevant to the capacity assessment. If the patient satisfies the two-stage test, you must respect their refusal, even if that refusal will likely lead to their death or serious harm.
And what about the duty of candor, the trap of trying to protect yourself?
It's the option that says, wait for the investigation before apologizing. This breaches the professional duty of candor. The sincere apology for the situation is expected immediately, usually within hours of the incident being identified. Waiting is seen as avoidance, and it just compounds the patient's distress.
And always remember, an apology is not an admission of liability.
Exactly.
What about the IG failures that come from trying to be convenient?
Two main ones here. First, send the whole record or all the notes just to be safe. This breaches the Caldicott principle of minimum necessary disclosure. It vastly increases the risk of a severe data breach because you're unnecessarily exposing highly sensitive, irrelevant information.
And the second?
Use WhatsApp or a personal phone to speed things up. This fails because it's an insecure, unapproved channel that bypasses all IT governance and auditing. Convenience never, ever outweighs security in the SJT.
Finally, refusing treatment that just feels wrong to a doctor, like refusing fluids or blood products.
The trap answer is, ignore the ADRT. Fluids or blood always helps. An advanced decision to refuse treatment, an ADRT, is legally binding if it's valid and applicable, especially when it refuses life-sustaining treatment. Ignoring it is unlawful assault. The high-scoring action is always to verify the validity and applicability of the ADRT and respect the patient's refusal.
Okay, time for the lightning round. I'm going to throw some scenarios at you.
Yeah.
Use the make safe process and our mnemonics to give me the immediate high-scoring action.
Ready.
A patient DMs your personal social media for clinical advice.
Reply. Cannot advise here. Use an official secure channel. Then disable DMs from patients. Document the interaction in the clinical record if they disclose clinical information.
A competent patient declines recommended surgery after you've explained the risks, but they insist they don't care about a minor side effect you mentioned.
Ensure Montgomery is met, including alternative. Confirm they understood the major material risks and their right to refuse. Document their autonomy and proceed with the non-operative plan.
An unverified caller claims to be a relative asking for results, and the patient is currently in theater.
Decline to give any details without explicit patient consent. Offer to arrange for the patient or their LPA to give consent post-procedure and call them back. Document the refusal to disclose. That's LOCKIT, Principle C.
A surgical swab is retained, which means an unplanned return to theater. That's classified as moderate harm.
Apologize now, that's candor. Make safe. Notify clinical governance immediately. Then initiate the formal CQC Reg 20 steps, like the written account and recorded apology, because the statutory threshold has been met.
A patient with poorly controlled epilepsy insists on driving and says they won't notify the DVLA.
Explain clearly that you have a public interest duty to disclose the minimum necessary to the DVLA if they refuse to act. If they remain resistant, proceed to disclose. And document your rationale, emphasizing the duty to protect the public.
A senior colleague asks you to falsify a handover entry to cover up an error they made.
Refuse immediately. That's a professional boundary and a GMC duty. Document the request and the actual error objectively. Escalate to your clinical supervisor or the FTSU guardian.
Okay, last one. A patient with a severe learning disability needs an urgent, non-life-saving blood transfusion. They're unbefriended and have no LPA or ADRT.
Instruct an IMCA immediately. Conduct a proportionate best interest discussion applying the Section 4 checklist. Proceed with the least restrictive option that is determined to be in their best interests. And document the IMCA request and your rationale fully.
That was comprehensive. If you remember nothing else from this deep dive, make it these 3 synthesized takeaways.
These are the core pillars.
Number 1, capacity first and autonomy supported. Always assume, assess, and support capacity using the 2-stage test. If capacity is lacking, you follow the MCA Best Interest Checklist Section 4 and immediately check for an LPA, an ADRT, or the need to instruct an IMCA for serious decisions. And respect Montgomery by tailoring your risk disclosure to the individual patient.
Number 2, minimum necessary and secure. For all information sharing, use LOCKIT, clarify the purpose, disclose the bare minimum necessary to achieve that purpose, and always use approved, secure, auditable channels for any identifiable data. Confidentiality is the default. Public interest or statutory duty must be rigorously justified and documented.
And number 3, safety and documentation define competence. Act immediately to stop harm. That's your Speak OP framework. Be promptly open and apologize when things go wrong. That's candor, both professionally and statutorily. And document the precise legal or ethical rationale for every single decision. The who, what, why, when, and under which lawful basis, be it MCA, public interest, or consent.
By internalizing these robust frameworks, capacity, candor, and confidentiality, you're not just scoring better in the SJT, you are building the legal and ethical defensibility that's required to be a safe, accountable, and trusted doctor from your very first day on the wards. Master the process and the high scores will follow. Good luck with your revision. And remember, high-yield structured revision materials and frameworks, including deeper dives into specific acts like the MCA, can be found at passmsra.com.